A Dhaka court on Sunday granted bail to at least 200 former Bangladesh Rifle soldiers in an explosive case filed over the BDR mutiny. All these soldiers have already been acquitted by both the trial court and the High Court in a murder case related to the rebellion staged at its headquarters, Pilkhana, in 2009. Soldiers taking part in the 30-hour-long mutiny in February 25-26, 2009 killed 74 people, among them 57 army officers who were deputed to the Bangladesh Rifles. While the murder case remains pending before the Appellate Division of the Supreme Court, many of the acquitted soldiers were held in custody as they were also accused in a separate explosive case tied to the BDR carnage. Dhaka Metropolitan Special Tribunal Judge Mohammad Ibrahim Mia granted bail after hearing petitions filed on behalf of 426 detained soldiers. The court recorded the deposition of retired Major Soyed Muhammad Yusuf as a prosecution witness as it resumed the explosive case trial, which was stalled for 12 years. The next hearing is scheduled for February 10. The court has so far recorded testimonies of 284 out of 1,264 witnesses under the Explosive Substances Act. The trial was stalled since the disposal of the murder case in 2013. The bail orders were issued on Sunday in the makeshift courtroom at Dhaka Central Jail in Keranganj amid ongoing protests from the families of the detained soldiers demanding their release. Deputy Inspector General of Prisons for Dhaka Division, Jahangir Kobir, said that 756 former BDR soldiers were held in custody in 4 jails in connection with the 2 cases filed over the rebellion, and of them 200 were granted bail on Sunday. On the day, 106 accused were produced in the court. Of them, 50 were already acquitted in the BDR mutiny murder case in both trial court and high court, 6 were on death row, and the rest 50 were serving various sentences in the murder case. Chief Public Prosecutor Borhanuddin said that the court, for granting bail, gave priority to those soldiers who got acquittal in the murder case but were detained in the explosive case. He added that the court was likely to issue release orders after 2 days as it received a list of soldiers meeting the criteria. He said that the BDR members' lawyers failed to mention the exact number of the accused who applied for bail and also the exact information on the number of personnel acquitted from both the lower court and high court. The trial court's decision came as a first step towards addressing the long-standing legal limbo affecting hundreds of soldiers detained under overlapping charges. Defense lawyer Aminul Islam estimated that 250 soldiers might qualify under the bail order, while Borhan put the number at over 200. On November 2013, the trial court sentenced 568 soldiers in the murder case. Of them, 152 were awarded death penalty, 162 were handed life imprisonment, and 256 were sentenced to varying jail terms. Of the total 850 accused in the case, 278, mostly former BDR personnel, were acquitted. In a 2-day judgment delivered on November 26, 27, 2017, the High Court upheld the death sentences of 139 soldiers and handed life imprisonment to 185 others. Additionally, it upheld varying jail terms for 200 convicts while acquitting 45 accused of all charges. Lawyer Aminul Islam said that the trial court had initially acquitted 277 soldiers. But after then, Awami League government appealed against acquittal of 69 individuals. The High Court handed life imprisonment to 20 of them. In December 2020, the Awami League government filed 20 appeals in the Appellate Division challenging the High Court verdict. One of the appeals challenged the High Court's acquittal of 16 soldiers. The lower court sentenced 12 of the 16 soldiers to life imprisonment and handed death penalty to the rest 4. The appeals now remain pending in the Appellate Division. Aminul Islam noted that the recent 426 bail applications included soldiers who had completed serving the sentence handed down by the High Court but remained in custody in the explosive case. He argued that many of these soldiers were already acquitted in the murder case and were likely to receive similar verdict in the explosive case. He further contended that the soldiers were in custody for 16 years, which constituted a strong basis for granting bail. Chief Prosecutor Borhanuddin opposed the bail petitions, arguing that there remained a possibility of convictions in the explosive case. He maintained that granting bail could undermine the ongoing legal process.